Welcome to episode 4 of the DFV Retailer Support Hub webinar series, which is designed to assist retailers to prepare for and respond to domestic and family violence and support employees who may be experiencing domestic and family violence at home. My name's Thomas, and I'm part of the team of the National Retail Association. As the modern voice of retail in Australia, we represent and support employers in the retail and fast food industries with training and advice on a number of employment-related matters, including supporting and managing workers experiencing domestic and family violence. The webinar has been created to assist employers to better understand domestic and family violence, and in particular, manage employee absences due to family and domestic violence, with a particular focus upon unpaid family and domestic violence leave. In this webinar, we will discuss the following: what family and domestic violence leave is, which of your employees can access it, and the process for applying for it. We'll also discuss other types of leave, both paid and unpaid, that an employee in this circumstance may be eligible for, and how an employer and employee can form agreement as to flexible working arrangements that can assist to maintain the employee's employment during this challenging time. In earlier webinars, we learned of the widespread effects domestic and family violence can have in the community, what family and domestic violence is, and the many forms it can take. For the purposes of this webinar, we will be paying special attention to the definition given in the Fair Work Act. This is because we'll be speaking about what leave is available to employees experiencing domestic and family violence. Under the Fair Work Act, family and domestic violence is defined as violent, threatening, or other abusive behaviour by a close relative of an employee that seeks to coerce or control the employee and causes the employee harm or to be fearful. As discussed in previous webinars, domestic and family violence can include emotional abuse, verbal abuse, such as yelling or shouting, stalking and harassment, such as constantly following or texting or phoning someone, financial abuse, such as withholding money necessary to survive or forcing them to hand over money, physical abuse, such as slapping or hitting or choking, strangulation, damaging property to frighten you, such as punching holes in a wall or breaking furniture, social abuse, such as not letting someone see their friends or family, spiritual abuse, such as forcing someone to attend religious activities, sexual abuse, such as coercing a person to have sex, and depriving someone of the necessities of life, such as food, shelter, and medical care. It is important to note that this definition restricts the definition of domestic and family violence to close relatives. This will mean that where domestic and family violence occurs, but the source of the violence is not a close relative, employees will not be able to access family and domestic violence leave. An example of this would be where the person engaging in violence is a carer or a friend of the employee. A close relative of the employee under the Fair Work Act is a person who is a member of the employee's immediate family or is related to the employee according to Aboriginal or Torres Strait Islander kinship. We have further clarification here where immediate family under the Fair Work Act is defined as being a spouse, de facto partner, child, parent, grandparent, grandchild, or sibling of the employee. Alternatively, it can also include a child, parent, grandparent, grandchild, or sibling of a spouse or de facto partner of the employee. What is family and domestic violence leave? Family and domestic violence leave is a type of leave developed to assist employees experiencing family and domestic violence, and it's a tool that assists people to take action to remove themselves from an abusive situation. A person experiencing family and domestic violence could access the leave to obtain legal advice, access support services, attend a police station or court, or arrange for relocation. To be able to do so during work time may greatly reduce the risk of detection by the person engaging in violence. Being able to access family and domestic violence leave also relieves an employee from the difficult choice between putting their ongoing employment and financial security at risk due to having unauthorised absences, versus the need to make arrangements to escape or protect themselves from the person engaging in violence. Having established the value of this type of leave, we can now turn to the details of how it can be accessed. Who can access family and domestic violence leave? Under Section 106 B of the Fair Work Act, an employee may take unpaid family and domestic violence leave if they satisfy the following 3 requirements. Firstly, the employee is experiencing family and domestic violence. Secondly, the employee needs to do something to deal with the impact of this violence. And finally, it's impractical for the employee to do that thing outside the employee's ordinary hours of work. The wording here is deliberately broad. The Act itself gives the example of an employee making arrangements for their own safety or that of a close relative, including relocation, attending urgent court hearings, or accessing police services. This could also include accessing medical care and counselling, or arranging new schools or childcare for children. These are time-consuming processes and cannot usually be performed during the employee's personal time when they're subject to the control of an abusive close relative. This entitlement is outlined in Section 106, capital A of the Fair Work Act. The employee is entitled to 5 days of unpaid family and domestic violence leave in a 12-month period. Further, unpaid family and domestic violence leave is available in full at the start of each 12-month period of the employee's employment, does not accumulate from year to year, and is available in full to part-time and casual employees in addition to full-time employees. It should be noted that for casual, seasonal, or employed for a specified task, the 12-month period begins at the start of their first employment with the employer. How can the leave be used? An employee may take unpaid family and domestic violence leave as a single continuous 5-day period, or separate periods of 1 or more days each, or any separate periods to which the employee and employer agree, including periods of less than 1 day. It should be clarified at this point that this section of the Act does not prevent the employee and the employer agreeing that the employee may take more than 5 days of unpaid family and domestic violence leave, nor does it prevent them from forming agreement for that leave to be paid. Further, an employee who is entitled, under a law of a state or territory, to leave as a victim of crime is also entitled to take family and domestic violence leave if applicable. The use of family and domestic violence leave does not prevent an employee from accessing leave as a victim of crime or vice versa. Notice and evidence requirements. An employee must give their employer notice that they are taking family and domestic violence leave. This notice must be given to the employer as soon as practicable, which may be a time after the leave has started, and advise the employer of the period or expected period of the leave. An employer can require that the employee provide evidence that would satisfy a reasonable person that the employee is eligible to take family and domestic violence leave. This would include evidence that the employee is experiencing family and domestic violence and the employee needs to do something to deal with the impact of the violence, and that it is impractical for the employee to do that thing outside the employee's ordinary hours of work. Before making a request for evidence, an employer should give careful consideration to the appropriateness of the request. Particularly, an employer should consider the very real risk that the employee is taking by trying to remove themselves or a close relative from an abusive environment. A request for evidence may deter the person from taking family and domestic violence leave and result in them continuing to endure that violence. Having considered these risks, if an employer still felt that it was appropriate to request such evidence, the following are examples of the types of evidence that could be sufficient, such as documents issued by a police service, documents issued by a court or legal representative of the employee, documents from a family violence support service, or a statutory declaration. An employee will not be able to take domestic violence leave if they do not comply with a request for evidence. However, an employer should exercise extreme caution and give careful consideration before choosing to deny a request for family and domestic violence leave, given what the consequences of a refusal could be. Privacy and confidentiality considerations. Personal information provided to an employer as part of requesting family and domestic violence leave may be regulated under the Privacy Act 1988. An employer must take steps, as far as reasonably practicable, to ensure that information that is provided as evidence to support a request for family and domestic violence leave is treated confidentially. Given that such an employee is already at risk, this is a very serious obligation upon an employer to handle and store such information appropriately. Particularly so if there is the potential that the person engaging in family or domestic violence may attempt to access that information. Importantly, the obligations to treat such information as confidential do not prevent an employer from disclosing such information if the disclosure is required by an Australian law or it's necessary to protect the life, health or safety of the employee or another person. If you're unsure whether you are subject to such legal obligation to disclose confidential information, it would be best practice to gain legal advice before disclosing, if possible. Other relevant forms of leave. An employee may require more than 5 days of unpaid family and domestic violence leave, depending on their circumstances. The family and domestic violence leave entitlement prescribed by the Fair Work Act is a statutory minimum. Nothing prevents an employer from offering an employee experiencing violence an additional unpaid leave. If an employee has exhausted their entitlement to family and domestic violence leave, and the employer is unwilling or unable to provide the employee with more of this leave, there are other types of leave that an employee can access, such as annual leave. An employee can make a request to take annual leave. Such a request can only be refused by an employer where it is reasonable to do so. Given the circumstances of family and domestic violence, it would likely be difficult for an employer to establish that it was reasonable to refuse the request in these circumstances. Alternatively, paid personal or carer's leave. Within the context of taking leave amidst family and domestic violence, an employee may take paid personal or carer's leave if the leave is taken where the employee is not fit for work due to suffering from a personal illness or injury caused by family or domestic violence. For example, this could include mental health issues and physical injuries. Alternatively, this could be relevant where the employee needs to provide care or support to immediate family or a member of the employee's household who is suffering from a personal illness or injury caused by family or domestic violence. Alternatively, it may be relevant where an unexpected emergency has occurred affecting a member of the employee's immediate family or household due to family or domestic violence. There is some ambiguity as to how far the term unexpected emergency can be interpreted in this context. The Fair Work Ombudsman has indicated that personal/carer's leave cannot be used to attend legal appointments or to access police services, since family and domestic violence leave can be used for this purpose. An example of such an unexpected emergency in this context would be needing to care for children due to them being deliberately left unattended by a person engaging in family or domestic violence in unexpected circumstances. Like for family and domestic violence leave, an employer can request evidence that supports the employee's request for personal or carer's leave. Such evidence could include a medical certificate or a statutory declaration. There's also unpaid carer's leave. An employee may take 2 days of unpaid carer's leave for each occasion where they would have been eligible to take paid carer's leave as outlined above. This will likely be taken in circumstances in which the employee has exhausted their accrued paid personal or carer's leave entitlement. Or there's unpaid discretionary leave. As discussed earlier, if an employee has exhausted their family and domestic violence leave, the employer may decide that it is appropriate in the circumstances to give the employee unpaid discretionary leave. This allows for a greater degree of flexibility, since the employee will not need to meet the requirements of taking family and domestic violence leave. This may be appropriate where the employee has previously demonstrated that they are experiencing family or domestic violence, and the employer does not deem it necessary for the employee to establish that they satisfy the requirements again. It's also important to note that there are some exceptions for casual employees. As casual employees are not usually entitled to leave, the situation is slightly different for them. Casuals can access family and domestic violence leave and unpaid carer's leave. However, casuals cannot access annual leave or paid personal/carer's leave. Flexible working arrangements. Under Section 65 of the Fair Work Act, an employee can make a request for flexible working arrangements if they're experiencing violence from a family member or if they need to provide care or support to a member of their immediate family or household who is experiencing family violence. By doing so, an employer and employee can come to an arrangement for how to organise an employee's work most effectively for both parties in light of the circumstances. However, an employee can only make such a request if they have completed 12 months continuous service with the employer. If they're a casual employee, they must also have been working for the same employer regularly and systematically for at least 12 months and have a reasonable expectation of continuing employment with the employer on a regular and systematic basis. A flexible working arrangement could include changes to work conditions such as hours of work, alternating and varying start and finish times, or use of split shifts to remove an easily predictable pattern, places the employee at risk of being detected by the person engaging in violence. Performance of duties, such as changing or adjusting the duties performed by the employee to remove them from a riskier situation, or the location of work, such as arranging for the employee to perform their duties away from their usual place of work to assist them in avoiding being located by the person engaging in violence. Process for requesting flexible working arrangements. An employee's request for flexible working arrangements must be made in writing, setting out details of the changes being sought and the reasons for the change. An employer then has 21 days to give the employee a written response stating whether the employer grants or refuses the request. An employer can only refuse such a request on reasonable business grounds. An employer can be more involved in the process, though, than merely accepting or refusing requests made, and can work with the employee to determine what an acceptable request would look like. This will be a more efficient way to establish a flexible working arrangement and may be beneficial for reducing the risk of the person who's engaging in family and domestic violence becoming aware of the request. Consideration should also be given as to how these requests can be made and recorded without raising the risk of detection by the person engaging in family or domestic violence. Best practice would be to store flexible working requests and related correspondence in a place that cannot be accessed by the person who's engaging in family and domestic violence. Also keep in mind that corresponding with the employee's personal email address or phone may not be possible. The person engaging in family or domestic violence may also have access to the employee's work computer and email accounts. So it may be better for a meeting about the request to occur in person while the details are recorded in writing. It should also be noted that modern awards tend to make provision for an employer and employee to form agreement as to how the employee performs work. Employers should give consideration as to whether a more beneficial agreement could be formed under such provisions. This webinar has hopefully reinforced that employers are uniquely positioned to assist employees to remove themselves from a dangerous and damaging situation through access to various forms of leave available to the employee at law and through the effective use of flexible work arrangements. Thank you for joining us today as we dive further into how an employer or co-worker can support someone in the workplace who may be experiencing domestic and family violence. Please join us for our next webinar, where we will discuss how to effectively manage the performance and conduct of an employee who is experiencing domestic and family violence. If any of the discussions we've had today have raised questions about your obligations as an employer, please don't hesitate to call the team of the National Retail Association on 1800 445 522. Finally, as mentioned earlier, if you or someone you know may be experiencing domestic and family violence, please seek support by calling the National Sexual Assault, Domestic and Family Violence Counselling Service on 1800-RESPECT. Also, 1-800-737-732, or DV Connect at 1-800-811-811 for women and 1-800-600-636 for men. Thank you.